Did you know that starting in February 2026, there are significant positive changes coming to the I-130 processing system that could drastically reduce waiting times for families trying to reunite in the United States? These changes could mean that applications that used to take years might now be processed in months. Families separated by borders could be reunited much faster, and the entire immigration process for immediate relatives and family preference categories could become more streamlined and efficient than ever before. If you have filed an I-130 petition for a family member, if you're planning to file one soon, or if you're waiting for your green card through a family-based petition, this video contains crucial information that could significantly impact your timeline, your strategy, and your family's future in America. Welcome back to US Immigration Intel, your most trusted and comprehensive source for the latest news, updates, and essential information about US immigration, visas, green cards, citizenship, and everything that affects your journey to living, working, and building your life in the United States. I'm here today to bring you some genuinely positive news about changes to the I-130 petition process that are being implemented starting in February 2026 by US Citizenship and Immigration Services, also known as USCIS. These changes represent one of the most significant improvements to family-based immigration processing in years, and they could have a profound impact on millions of people who are trying to bring their loved ones to the United States or who are waiting for their own green cards through family sponsorship. I'm going to explain exactly what's changing, why these changes are happening, who will benefit the most, what the new processing times look like, and most importantly, what specific actions you should take right now to maximize the benefit of these improvements for your own case. This video is absolutely essential for anyone involved in family-based immigration, whether you're a US citizen petitioning for a spouse, parent, or child, a lawful permanent resident sponsoring family members, or a beneficiary waiting abroad for your visa to become available. Make sure you stay until the very end, because I'll also share important tips about how to avoid delays and common mistakes that could still slow down your case even under the new system. Don't forget to subscribe to US Immigration Intel and hit that notification bell so you never miss critical updates like this that could change your immigration timeline and bring your family together sooner. Let's dive straight into what these changes are and why they represent such positive news for families. The I-130 petition, officially called the Petition for Alien Relative, is the foundational document that US citizens and lawful permanent residents file to sponsor family members for immigration to the United States. This petition establishes the family relationship and is the first step in the process of obtaining a green card through family sponsorship. For years, one of the biggest frustrations and pain points in the US immigration system has been the extraordinarily long processing times for I-130 petitions. Depending on which USCIS service center was handling your case and which category of family member you were sponsoring, processing times could range anywhere from several months to over 2 years just to get the initial I-130 petition approved. And that's before even beginning the consular processing or adjustment of status process to actually get the green card. These long delays have caused immense hardship for families, forcing spouses to live apart for years, preventing parents from attending their children's graduations and weddings, and creating financial and emotional strain on millions of families. Starting in February 2026, USCIS is implementing several major changes that are designed to dramatically reduce these processing times and improve the overall efficiency of family-based immigration. The first major change is a significant increase in staffing and resources dedicated to processing I-130 petitions. USCIS has hired and trained hundreds of additional immigration officers specifically focused on family-based petitions, and they have allocated more funding to technology improvements and process optimization. This increased capacity means that the backlog of pending I-130 petitions that has built up over recent years can finally start to be worked through more quickly. The second major change is the implementation of new technology systems that allow for more efficient case processing, better tracking of applications, and automated handling of certain routine aspects of petition review. These systems use advanced document verification technology, digital workflows, and enhanced communication tools that reduce the amount of time officers need to spend on each case while maintaining thorough review standards. The third major change, and this is particularly exciting for many applicants, is the expansion of premium processing options for I-130 petitions. Previously, premium processing, which guarantees a decision within 15 business days for an additional fee, was not available for most family-based petitions. Starting in February 2026, USCIS is rolling out premium processing for immediate relative categories, which includes spouses of U.S. citizens, unmarried children under 21 of U.S. citizens, and parents of U.S. citizens who are 21 or older. The premium processing fee for I-130 petitions will be $2,500, which is a substantial amount. But for families who have the resources and who are desperate to speed up their cases, this option could reduce what might take 12 to 18 months down to just 15 business days for the initial petition approval. This is an absolute game changer for families who can afford it and who need to reunite quickly for medical reasons, business opportunities, or simply because the separation has become unbearable. The fourth major change involves the way USCIS handles requests for evidence, commonly known as RFEs. In the past, if USCIS needed additional documentation or clarification about your petition, they would issue an RFE, which would pause your case processing and often add many months to your timeline while you gathered the requested documents and submitted them, and then waited for an officer to review your response. Under the new procedures starting in February 2026, USCIS is implementing more specific and detailed initial filing instructions to help petitioners submit complete applications from the start. They're providing online resources and checklists that make it clearer what evidence is needed, and they're training officers to issue more targeted and specific RFEs when they are necessary, with clearer explanations of exactly what's needed. Additionally, USCIS is piloting a new electronic RFE response system that allows petitioners to upload documents directly to their online account rather than mailing physical copies, which significantly speeds up the response process and reduces the risk of documents getting lost in the mail. The fifth change relates to how USCIS prioritizes cases within the processing queue. Under the new system, certain categories of cases will receive expedited handling based on humanitarian factors, significant public benefit, or other compelling circumstances. For example, petitions where the beneficiary has a serious medical condition, cases involving military families, situations where there are minor children affected by the separation, or cases where the petitioner has a documented urgent need may be moved to the front of the processing line. While expedite requests have always been possible, the new system makes the criteria clearer, the process more standardized, and approvals more likely when legitimate urgent circumstances exist. Now, let's talk about the specific processing time improvements you can expect under the new system. For immediate relative petitions filed by U.S. citizens for spouses, parents, or unmarried children under 21, the standard processing time is expected to drop from the current range of 12 to 24 months down to approximately 6 to 9 months for most cases. That's a reduction of roughly 50% or more in processing time. For those who opt for premium processing, as I mentioned, the initial petition approval could come in as little as 15 business days, which is about 3 weeks. For family preference categories, which include unmarried adult children of U.S. citizens, spouses, and unmarried children of lawful permanent residents, married children of U.S. citizens, and siblings of U.S. citizens, the processing time improvements are also significant, though not quite as dramatic. These categories are subject to annual numerical limits and visa bulletin priority dates. So, even with faster petition processing, beneficiaries still need to wait for their priority date to become current before they can proceed to the next step. However, getting the I-130 approved more quickly means you establish your priority date sooner, which can ultimately reduce your total waiting time. It's important to understand which categories of family-based immigration will benefit most from these changes. U.S. citizens petitioning for immediate relatives, meaning spouses, parents, and unmarried children under 21, will see the most dramatic improvements because these categories are not subject to annual numerical limits. So once the I-130 is approved, the beneficiary can generally proceed immediately to consular processing or adjustment of status without waiting for a visa number to become available. This means that the total time from filing the I-130 to obtaining a green card could potentially be reduced from 3 or 4 years down to 1 year or even less in some cases. Lawful permanent residents petitioning for spouses and unmarried children will also benefit significantly from faster processing, though they still need to wait for priority dates in the Family Second Preference category, which currently has backlogs of several years depending on the beneficiary's country of origin. Let me give you some concrete examples to illustrate how these changes could impact real families. Example 1. Maria is a US citizen who wants to petition for her husband who lives in Mexico. Under the old system, she would file the I-130 and wait approximately 15 to 18 months for approval. Then her husband would wait for the National Visa Center to process their case, which takes another 6 to 9 months, and then schedule a consular interview, which could take another 3 to 6 months, depending on the embassy's workload. Total time from filing to green card, approximately 3 to 3 and 1 to 2 years. Under the new system starting February 2026, if Maria pays for premium processing, her I-130 could be approved in 15 business days. The National Visa Center processing hasn't changed, so that's still 6 to 9 months, and the consular interview still takes 3 to 6 months. But now the total time is approximately 1 to 1 and 1 to 2 years, saving nearly 2 years of separation. Even without premium processing, if the standard processing time drops to 6 to 9 months, Maria and her husband save about 9 months to a year compared to the old system. Example 2. John is a lawful permanent resident who filed an I-130 for his adult unmarried daughter who lives in the Philippines. This falls under the Family Second Preference B category, which currently has significant backlogs, especially for applicants from the Philippines. Under the old system, John's I-130 might take 18 to 24 months to be approved. Then his daughter would need to wait for her priority date to become current, which based on current visa bulletin trends might take 6 to 8 years for Philippines natives in the F2B category. Under the new system, John's petition might be approved in 6 to 9 months, which doesn't change the priority date wait, but it does establish that priority date earlier, effectively moving his daughter up in the queue by about a year. Additionally, if John becomes a US citizen during the waiting period, the petition can potentially be upgraded to the Family First Preference category, which has shorter wait times. And having the approved I-130 in hand makes that upgrade process smoother. Example 3. Sarah is a US citizen who wants to petition for her elderly mother who lives alone in China and has serious health problems. Under the old system, Sarah would file the I-130, wait 12 to 18 months for approval, and then proceed with consular processing. Under the new system, Sarah can request expedited processing based on the humanitarian factors of her mother's age and medical condition. If approved for expedited handling, her I-130 might be processed in 3 to 4 months instead of 12 to 18 months. Alternatively, if she uses premium processing and also requests expedition of the subsequent steps, she could potentially bring her mother to the United States in under a year instead of 2 to 3 years. What specific action should you take right now to maximize the benefits of these positive changes? First, and most importantly, if you haven't filed your I-130 petition yet, but you're planning to, it may be advantageous to wait until February 2026 when the new system is in place, especially if you're in a category that will be eligible for premium processing and you have the resources to pay for it. However, if your priority date matters significantly for your category, such as in heavily backlogged preference categories, it might be better to file now to establish your place in line, even if it means longer initial processing. Consult with an immigration attorney to determine the best strategy for your specific situation. Second, if you've already filed an I-130 that's currently pending, you should receive information from USCIS about whether your case will automatically benefit from the new processing improvements or whether you can take any actions to request expedited handling or upgrade to premium processing for a fee. Check your online USCIS account regularly for updates and notices. If you filed your petition online through the USCIS electronic filing system, you may have more options to interact with your case and request expedited processing than if you filed by mail. Third, whether you're filing a new petition or have one pending, make absolutely sure your petition is as complete and thorough as possible with all required evidence and supporting documentation. The new system is designed to process cases more quickly, but that benefit only applies to well-documented cases that don't require RFEs or additional evidence requests. Take the time to carefully review the USCIS instructions for the I-130 petition. Gather all required documents such as proof of your US citizenship or lawful permanent resident status, proof of the family relationship like marriage certificates or birth certificates, proof that any previous marriages were legally terminated, financial documents showing you can support your family member, and any other evidence relevant to your case. Consider working with an experienced immigration attorney to review your petition before filing to make sure everything is in order. Fourth, if you're in a situation where you have urgent humanitarian reasons for expediting your case, document those reasons thoroughly. Get letters from doctors about medical conditions. Gather evidence of threats or danger in the beneficiary's home country. Obtain documentation of any other compelling circumstances. And be prepared to submit a formal expedite request with strong supporting evidence. Under the new system, USCIS is more receptive to legitimate expedite requests, but you need to prove your case meets the criteria. Fifth, be aware of the premium processing option if you're in an eligible category and you have the financial resources to use it. The $2,500 fee is substantial, but if it means reuniting with your spouse or parent 18 months earlier than you otherwise would, many families will find it worthwhile. Start saving now if you think you might want to use premium processing and be ready to submit that request as soon as your category becomes eligible. Sixth, stay informed about your priority date if you're in a preference category. Even with faster I-130 processing, you still need to track the visa bulletin each month to know when your priority date becomes current and you can proceed to the next step. Set up alerts or regularly check the State Department's Visa Bulletin website so you don't miss your window to take action. Seventh, prepare for the next steps even while your I-130 is pending. If your beneficiary will be processing through a US consulate abroad, familiarize yourself with the consular processing steps. Gather the civil documents that will be needed like birth certificates and police certificates and start preparing for the medical examination and interview. If you'll be adjusting status within the United States, start gathering the documents needed for the I-485 application. Being ready to move quickly to the next step as soon as your I-130 is approved will help you maintain momentum and avoid unnecessary delays. It's also important to be aware of some potential challenges and things to watch out for even under the new improved system. First, premium processing, while faster, doesn't guarantee approval. It only guarantees a decision within 15 business days. If your petition has issues or insufficient evidence, it can still be denied under premium processing. Make sure your case is strong before paying the premium processing fee. Second, faster I-130 processing doesn't speed up all the other steps in the immigration process. You still need to go through National Visa Center processing, consular interview scheduling, medical examinations, and various security and background checks. These steps have their own timelines that aren't directly affected by the I-130 processing improvements. Third, country-specific backlogs in certain preference categories remain a significant issue. If your beneficiary is from a country with severe visa bulletin retrogression, like Mexico, India, China, or the Philippines in certain categories, the wait for a visa number to become available may still be many years, regardless of how quickly the I-130 is processed. Fourth, USCIS fee increases may be coming in the near future. While the premium processing fee is set at $2,500, the standard I-130 filing fee may also increase as part of broader USCIS fee adjustments. If you're planning to file, keep an eye on fee change announcements and consider whether filing before a fee increase makes sense for your situation. Fifth, policy changes are always subject to potential reversal or modification. While these February 2026 improvements are based on USCIS operational changes and resource allocation rather than changes in law, future administrations or budget constraints could potentially impact the continued implementation of these improvements. Take advantage of the faster processing while it's available. Let me also address some common questions and misconceptions about these changes. Question 1. Will pending I-130 petitions automatically be processed faster under the new system? Answer: generally yes. Petitions that are already in the queue should benefit from the increased staffing and resources, though the degree of improvement may vary depending on which service center is handling your case and how long it's been pending. Question 2. Can I upgrade my already filed petition to premium processing? Answer: USCIS has indicated that for immediate relative petitions filed after February 2026, you may be able to upgrade to premium processing by filing a separate request and paying the fee, but this option may not be available for petitions filed before the new system was implemented. Check with USCIS or consult an attorney for specific guidance. Question 3. Does faster I-130 processing mean I'll get my green card faster? Answer: it depends on your category. For immediate relatives of US citizens, yes. Faster I-130 processing should translate to faster overall green card processing. For preference categories subject to visa number availability, faster I-130 processing means you get in line earlier but doesn't necessarily speed up when a visa number becomes available for you. Question 4. Will these changes affect my ability to bring extended family members who aren't immediate relatives? Answer: the processing time improvements apply to all I-130 categories, but the most dramatic improvements are for immediate relative categories. Siblings, adult children, and other preference category beneficiaries will see some improvement, but will still face numerical limits and priority date backlogs. Thank you so much for watching US Immigration Intel today. If you found this information about the positive I-130 processing changes coming in February 2026 helpful, encouraging, and valuable for your family's immigration journey, please give this video a big thumbs up and share it with other families, friends, or anyone you know who is going through the family-based immigration process and could benefit from knowing about these improvements. We're here at US Immigration Intel every single week, bringing you the latest news, comprehensive explanations, and practical guidance about US immigration, visas, green cards, citizenship, and everything that affects your American dream. Subscribe to US Immigration Intel if you haven't already, and make sure to turn on notifications by clicking that bell icon so you never miss important updates like this that could significantly impact your immigration timeline and your family's future. Stay informed, stay prepared, take action when opportunities arise, and I'll see you in the next video with more essential information to help you navigate the US immigration system successfully. Take care and good luck with your family's petition.